Gulf Islands.
Thank you, and I really do want to thank my honorable colleague from Winnipeg, and I'm so sorry that, and I'm grateful to her for splitting her time with me. This day's debate, I don't want to attribute motivations and the reasons we're doing it or which side is right or wrong, but the problem is it's posing a question as if it's a live issue that needs to be addressed, and that's largely due to misunderstandings and misinformation. So let me try, because I am a British Columbia MP, so when other British Columbia MPs say that the proof of the fact that the court decision has created real problems is that we're getting calls in our constituency office. So I can say, yeah, I'm getting calls in my constituency office, and I'm getting constituents emailing me, and I take it as my responsibility to dig in to what the court said and to share with my constituents. I want to reassure you, there's no threat to your fee simple ownership of your place. There is no threat to ownership of land by settler culture British Columbians at all from the Cowichan decision. So I want to go back to what it is about, because what the court did, and it's a declaration of the British Columbia Supreme Court, and I wish, by the way, I think the Prime Minister was wrong to stand in this place and commit to appealing, and I think the British Columbia Premier should be ashamed of his running away from DRIPA and his decision to demonize this decision as if it puts anything into a state of confusion at all. I'm more upset with the Premier of BC because he is a lawyer, so he should know better. Prime Minister isn't, and the Leader of the Opposition isn't. And I dig into these things because I think it's my job. I'll never forget one of my favorite professors at law school, and Mr. Speaker, he used to thwack a cane across a desk right in front of it. It was like something out of Paper Chase on TV. And he'd say, develop the habit of thoroughness. So I've dug in. I've learned more about what this is about, and I want to share it with people because I think it will help take the notion that this is in any generalized way, that the Cowichan decision has anything to say about fee simple property rights in Canada. What the court said was that British Columbia, the British Columbia government has a duty to negotiate in good faith with the Cowichan, now that the facts are clear, in, quote, a manner consistent with the honor of the Crown. Now, we use the term honor of the Crown quite loosely, and the minister responsible for Crown Indigenous relations, this isn't some anachronism that we still talk about the Crown. That's at the essence of Indigenous nations' relationships with the country of Canada, is something that happened before there was a country of Canada, the Crown. The Crown's relationship with nations that were here before we got here. So in this case, what happened? Because it is an interesting story, and I hope that other colleagues here will realize how specific this was to a specific historical injustice, not a generalized one. What happened here, and again, to the honor of the Crown, the first governor of British Columbia appointed by the Crown, Governor James Douglas, was a very interesting person and a person of real integrity. He was, interestingly enough, and I won't digress too much about James Douglas, but he was black. He married an Indigenous woman when he came to BC, so his mother was black, his father was Scottish. He was our first governor of British Columbia. And he set a moral tone that was fascinating. With 8 engineers at his side, not armed once, he stood down a whole bunch of armed folks coming up from the U.S. I know we sometimes think about this now and hope it never happens, but he stood down a whole bunch of armed folks from the U.S. who, in the mid-1800s, were coming up to B.C. in the gold rush. They were armed to the teeth. They said they wanted to kill Indians, and they wanted to get our gold. And Sir James Douglas, how the heck he did this, I don't know, but it's a great story, with 8 engineers, stood down, and he said to them, you're entering British Empire now. Put your guns over there and queue up over there to buy your license to go pan for gold if you want on the Fraser River. Astonishing. Sir James Douglas, Governor James Douglas, also negotiated with the Indigenous nations, particularly in the region I'm honored to represent here, the Saanich nation. There were a lot of individual nations that entered into negotiated agreements with the Crown. Through Sir James Douglas, they're called the Douglas Treaties. And they're really fair and largely ignored over the generations. Now, Sir James Douglas specifically said to the Cowichan Band, and this particular court decision is about one specific village site on Laylu Island that had been occupied for a very long time, as proven in this, by the way, the court case we're talking about is over 800 pages long, and much of it is about this story. What happened? What was the double cross? Was there a double cross? What happened? So you go back. Sir James Douglas, in 1853, and again in 1859, assured the Cowichan people that this particular village site on Laylu Island, which I think is pronounced Tl'Clwncadon, but I'm probably getting it wrong, that had been heavily populated, an important village site, would always be Cowichan lands. They set it aside in reserve. That's what Sir James Douglas did. He was an honorable man. Unfortunately, a little later in our history, along comes Colonel Richard Moody, who was given the job of being land commissioner for the province of BC. So the Cowichan had a specific commitment from the governor. This is where you can stay. This is reserve land for you. We're basically, by the way, we're taking everything else, but this is reserve land for you. And then along comes Colonel Richard Moody, who later on, not that much later on, within about, about 10 years later, he comes along as land commissioner, and he buys the land for himself as a land speculator. So he dishonors the honor of the crown. He is, and as the court found out, and as the court described it, surreptitiously purchased the land for himself to make himself rich, while violating a commitment of the crown to the people of the Cowichan Nation. Now, time goes on, but the Cowichan people, don't forget, this is actually their land. They had a commitment from the crown, from Sir James Douglas. And the skullduggery of Colonel Richard Moody can't dishonor the crown. So the Cowichan never gave up. They launched a court case in 1911, saying, this is our land. The chief of the Cowichan actually in 1913 traveled to London, England, and met with King Edward VII to say, this is our land. Can you please repair this injustice that's been done to us? Well, as you can see, I mean, time marches on. They're still trying to get a resolution to this. The gold rush of 1858 was, again, what triggered Colonel Richard Moody's double cross. It's what, as I said, Sir James Douglas stood them down. The history of British Columbia is fascinating. I find it fascinating. But this case isn't about any kind of generalized discussion of Indigenous land title versus fee simple title. Not at all. Not ever. This is about a very specific injustice to a very specific nation over very specific land that was always theirs. That's what the court said. And then the court said, because the land now is basically Crown land and Vancouver Fraser Port Authority, so it's saying, and the BC government has no legal right to extinguish title. That's federal, as the honor of the Crown to these peoples. As my friend, who was once the Green Party member of the legislature representing me, he's Sartla First Nation, Adam Olson, in response to this Cowichan decision, tried to emphasize, quote, when First Nations win, the rest of society does not lose. And I'd like my honorable colleagues in this place to think about how significant it is for us all that what may knit us together, our sovereignty as a nation, is better protected by the honor of the Crown and its relationship with Indigenous nations than almost anything else. If we're dealing with a U.S. president that thinks we could be the 51st state, lots of luck. Section 35 of our Constitution says Indigenous lands are inherently held and are Indigenous title. Now, it's very important, again, and some of us have gone to law school in this place, like the Honourable Member for Nanaimo Ladysmith, so I know she knows this stuff, but you can't conflate title, Indigenous title, with fee simple title. It's like saying, if it's Crown land, Crown land is in a different kind of category, and in that sense, Indigenous title is more like that, akin to that. As my honourable colleague from Winnipeg has said, we have the Haida decision, the Delgamuukw decision, but really the Chilcotin decision of the Supreme Court of Canada made it really clear. Fee simple title is held specifically and personally and can be bought and sold. Indigenous title, as the court said in Chilcotin, is collective and intergenerational. So in the 5 seconds I have left, Mr. Speaker, please, all concerned, please let's not let people believe something that isn't true. This Cowichan decision doesn't threaten fee simple land or property rights. Let's wait for the courts to conclude, and let's stay calm.